case briefs, and so much more. LSData's got what you're looking for.
The Supreme Court recently presided over a contentious case concerning the requirement of exhausting administrative remedies before resorting to judicial review. The dispute originated from a business strategy devised by real estate developer R. Gordon Darby and mortgage banker Lonnie Garvin Jr., in which they leveraged multifamily developers to obtain single-family mortgage insurance from the Department of Housing and Urban Development, HUD. This plan, however, eventually fell apart, but not before the government was saddled with over $6.6 million in insurance claims due to Darby's default. The lawsuit hinged on a crucial question: should Darby or any plaintiff in similar situations be mandated to exhaust all possible administrative appeals before initiating a lawsuit, even if such a requirement isn't explicitly dictated by agency rules or the law itself? This question led to a close scrutiny of the relationship between the exhaustion of administrative remedies doctrine, an integral part of procedural jurisprudence, and the provisions of the Administrative Procedure Act, APA. At the initial proceedings, the Fourth Circuit Court of Appeals ruled that exhaustion of administrative remedies wasn't necessary in this case. They supported their decision with the assertion that there was no legal mandate requiring such action. On appeal, however, the Supreme Court disagreed with the lower court's denial of the respondent's motion to dismiss. In its ruling, the Supreme Court clarified the parameters of Section 10(c) of the APA, which offers agencies the latitude to require an appeal to a higher authority before an examiner's initial decision becomes final. The court emphasized that the exhaustion doctrine holds in cases where it is mandated by statute or agency rules. In cases not governed by the APA, courts still hold the discretionary power to impose the exhaustion of administrative remedies. This landmark ruling thus established that the exhaustion doctrine is functionally encoded in Section 10(c) for all legal disputes under the purview of the APA. Furthermore, the court can't impose an exhaustion requirement as a procedural rule when the agency action in question has been declared final under Section 10(c). As a result of this decision, the case has been remanded for further proceedings in line with the Supreme Court's interpretation of the relationship between the APA and the exhaustion of administrative remedies doctrine. In this insightful ruling, the court has shed light on the intricacies of procedural law, providing valuable guidance for future litigations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsc.law, elevate your mind, leave the stress of class.